Community Motors West Side, the GM Superstore next to Cinema West. Community Motors of Mason City, we give you more.
Okay, ERS, or HGR, WPA, whatever they're called.
I'd like to break down what I report to you on this into basically three categories. I want to talk to you a little bit about the process that we've been going through to get to where we are. And then I'd like to walk through at least certain sections of the agreement, and I'll pass out what I have at this point. And then I want to talk about what comes next and what I foresee as other things that you're going to need to be considering. In terms of the process, I started working on this the Friday after the last board meeting on a Thursday night. And I don't think a day has gone by since then that I haven't given at least an hour or two to this, and on several occasions, entire days. And that includes Saturdays and Sundays too, according to exceptions. Jacqueline Arthur on the other side has been responsive. I have had 2 meetings with her, one in my office for approximately 3 hours, and another one by telephone for approximately an hour. In addition to that, I've had regular ongoing conversations with her of lesser periods of time. Bill and I have been in regular contact. I've also been in regular contact with Mark Landa and Kurt Hartog. Bob Bamsey has been in contact with Bill, and that has gotten around to me typically, although I've gotten some direct emails from Bob. So that's the attention that we've been giving this, Bill and I in particular. Just to refresh your recollection, Mark Landa is an attorney with the West Des Moines firm. Some years ago, he was the attorney for the Iowa Department of Natural Resources. You directed at a recent meeting that we engage him, and he was willing to accept the employment. What he has helped us with, and it's not been major, but it has been significant, I think confirmed the wisdom of your decision to engage somebody from the outside, particularly with his level of expertise. Kurt Hartog has been helpful also. Again, he's been folk, and he has emailed comments on drafts of this agreement. And there have been at least 6 or 7 that have been circulated, and many, many more that never got out of my office because they were redone and redone before they went out. But typically, procedurally, what I would do, I took the initial agreement and basically rewrote it. And what you're going to look at today, there's very little resemblance to what you've seen. But I would typically, after working on the agreement, send out a red line version of it to indicate what changes have been made. In going over the last several weeks, I have sent out only the clean copies because the red line had gotten to the point where it was almost counterproductive to fight through it and figure out what we were trying to read. Bill's help has been tremendous on this, his insight. Anyway, that's basically the process we're going through. Now, what I'm going to give you is a clean version of this that I finished up late last night. And the timing of it, in part, was related to the fact that the most recent draft had gone out last Thursday. And only at about 3 or 3:30 yesterday afternoon did I get a substantive response from the other side with respect to that draft. Mr. Jaworski was in the air for a couple of days, and apparently there was some difficulty letting him down. I am told, incidentally, that he is available by phone today if you have any questions or reason to contact him. I would say I don't think that's going to be necessary. If you did, this remains an open meeting, and however that is handled, you're going to have to make sure that everybody that attends your open meeting is able to hear what he says. On the agreement, Section 2 contains a number of definitions. The initial draft of this did not have definitions. I think they are helpful and useful. Most of the definitions come from either the Iowa Code or the Iowa Administrative Code. To get your arms around this sort of thing, you have to plow through scores and scores of pages in the Iowa Administrative Code and the Iowa Code, which deals with this. Landfill activities are some of the most heavily regulated in the industry that I'm familiar with. And therefore, there is a vernacular that is created within the industry that is unique to it. And that's why I think these definitions are critical. The ones that I think are important: alternate daily cover, beneficial use, construction and demolition waste, exceptional event, hazardous waste, solid waste. The term MSW, or municipal solid waste, had been used throughout the first draft of the agreement. That's a term that we use often. The fact of the matter is, I don't think it's defined in Iowa law. Solid waste is the basic universal term for the sort of waste that comes in here. But then there are a number of exceptions to that, or at least separately defined terms, including others that are in here. Special waste, for example, which follows yard waste, hazardous waste, household hazardous waste, and just some. Another important definition is waste management hierarchy, which you find near the bottom of page 2. Waste hire is given to actually two separate definitions, depending on whether the waste tire, depending on whether the unused tire has a rim or not, believe it or not. But I've used the term that doesn't refer to the rim. Yard waste is also an issue on page 3. The way I perceive this is that ERS wants basically three categories of waste. It wants the solid waste, it wants the construction and demolition waste, and it wants waste tires. So I've started to limit references to what it would take to those three categories of waste. You first see that pop up in paragraph D at the bottom of page 3. The original draft of this agreement had used the verb transfer in the context of provisions that would have had the landfill transfer waste to ERS. I don't think that was ever contemplated, and I have gotten rid of that verb in here. What you will do is permit the delivery of it to ERS. On page 4, paragraph D, the renewal of this agreement has been an issue. We know the initial term is 10 years. The suggestions I received was, well, anything beyond that should be reduced, or there should be some room for further negotiation. The best I was able to do on that was get a 15-year fixed term initially with a 5-year renewal, in essence, over the 10. But then in subparagraph II there on page 4, last paragraph, the second 5-year term, which would be called the second renewal term, would be subject to such new and additional terms and conditions as would be negotiated by the parties. So in effect, 15 years fixed based on the terms that are in here. Last 5 negotiable. Page 5, some of the pages are a little different. I'm working off a somewhat different draft of this. Actually, the red line draft, but paragraph 5, delivery of materials is where I want to be now. This and paragraph 6 are probably the guts of this thing. Here again, there's reference to what would be accepted or received or deliverable to ERS. There is an exception built into paragraph B on page 5 for, first of all, alternate cover material with specific reference to the bare flood. 2 is yard waste. Remember, there's a definition for that right in front of this. 3 is asphalt shingles, suggested by Bill. Asphalt shingles does show up in the waste management hierarchy. There's a defined term for that under the Iowa Administrative Code. However, Bear is very interested in your asphalt shingles because there's a high BTU content. Bill says that those shingles can be ground up and used either in base for pavement or in repavement itself, or the product, or as a small part of the pavement, the asphalt. Anyway, Bear wants us to reconsider the position that is built into this, that you would retain these asphalt shingles. And they want that reconsideration basically because of the high BTU content. And the argument they would make is that there is no existing program for the disposition of asphalt shingles out here. I don't know whether that's true.
We do not have one currently.
Okay. So I'm going to need some direction on that.
Just a quick question, I don't want to interrupt you, but one thing about it, we run, city garbage service, but I also do what I call special pickups, and part of that is shingles. And shingles would be mixed in, but are also, again, garbage. We have to separate that now.
No, I'll get to that.
Okay.
No, the short answer is no.
Yeah.
The next item is Roman numeral 4 there, and that is designed to retain on the landfill's part a certain flexibility with materials that in the future may be added to the waste management hierarchy as recyclables, recoverables, reusables. We don't know exactly what that might be. There's often talk about food waste, and there perhaps could be other things. This is objectionable to ERS because the lack of a predictable stream of waste concerns them. I understand that from a business standpoint. The argument I made on that when we discussed it, Arthur and I, was that here you have an ideological split. In that the landfill is looking at this from an ecological and environmental standpoint. And it is also interested, regardless of what else happens, in reducing waste that has to be buried. So that if at some point in the future there's a determination made that part of the waste stream that you have now is reusable and need not be buried, you want the option to pull that out rather than having it burned, which is not high on the waste management hierarchy. I think my argument is understandable, but I can't win it because it's too important to them to have a predictable stream of waste. So I'm going to need direction on how to deal with that before we're done. The rest of 5 pretty much has to do with what goes where. There will be testing of anything that they send out here. Anything that they are not supposed to have will be sent out here at their cost. They would pay for all the testing and transportation. They would be responsible for any hazardous releases, that sort of thing. On the issue of responsibilities on their part, Barney, this is addressing your question. Sub-paragraph D of paragraph 5 relates to their obligation to provide handling oversight and sort and segregate all waste. So that's their job, that's not our job. Paragraph K on page 6 has to do with tipping fees. you have the continuing right to charge whatever tipping fees you feel appropriate or any other fees that you feel appropriate. And put any other language in there because at some point there may be an argument by somebody that that's not a tipping fee. It can't be a tipping fee because you're not tipping it anywhere in the sense of putting it in a landfill. So there may have to be a semantic change at some point in the future with respect to that. However, as you read through that, you'll see that there is provision for a credit relative to tires. Bill told me that last year you received about 6,700 tires, 200 tons, and I think ERS contemplates being able to go out into the area and collect more tires that otherwise wouldn't have come here. So on the one hand, they would recognize the fact that you historically have received tires and they don't want to interrupt what you've received. On the other hand, they don't want to be limited in getting those additional tires in terms of capacity. Well, the best solution I could come up with on that was what you see here. That for the first 200 tons, that's just like any other garbage. And we get tipping fee. Beyond that, there's a credit, so you have a wash. I don't think that's going to be acceptable with ERS. I think they want to be able to go out and solicit tires, the very first tire, not being subject to tipping fee. They'll would have some comments on this, I'm sure, but in any case, that's a major question because, again, BTU content of tires high, and this will be important for their waste stream. Whether it's in this section, this paragraph 5, 6, or later, a couple of things I want to point out. There is language all over this thing to the effect that what we're talking about here is waste from and within the geographic area of the service communities. The from part of it has to do with the contacts and the contracts you have with the communities themselves. The within the geographic area has to do with the other waste haulers. And ERS will be limited to waste that comes from those two sources, municipalities within the geographic area of the municipalities. In other words, they can't bring waste from the outside in as feedstock or whatever the purpose is. Page 6, page 7, monitoring and recordation of the tonnage. As you'll recall, one of the concerns has been that there was an expectation the landfill would have some of its employees on the ground over there at ERS, and there were numerous complications with that. What this says is basically the landfill may, in order to ensure that there's appropriate monitoring and recording of what is delivered there, establish one another combination of certain means and methods, including the installation of devices that would permit off-site recording and monitoring. In other words, somebody could sit at the desk here, watch a screen, and see what's going on over there. Barney brought up the question of, well, what if we're not open? Would this be done? Barney, what I plugged in subparagraph B there is simultaneous and time delayed monitoring and recordation. So if you come in the next morning, you turn the screen on and you can go back and follow through everything that happened overnight. You can see what they would be obliged to provide you in the way of information that's set out in subparagraph C, and I'm going to go through all that, but I think it's pretty comprehensive. Obviously, you're going to need the weight, the nature of the waste, who brought it in, and the source of it. Paragraph E on page 8, the question of reimbursement for your costs. They had offered originally $30,000 per year contemplating that there would be some landfill people on their site. Last meeting of the board, when we talked about the remote monitoring, which would make it unnecessary to have somebody on the site, Arthur runs up to me immediately after the meeting and says, well, now that $30,000 was ticketed or targeted or connected to those people on our site, so of course that's not in play anymore. Well, you can see I've revisited it here because you're still going to have somebody having a function of monitoring that work. Now, maybe somewhat less if you have sustainable work. Nevertheless, the number is now $50,000 per year, and it's directly connected to that sort of activity. This part of the agreement, I feel pretty good about, because you have all the flexibility in terms of how this can be handled. You're going to get paid something for it. The cost of installing all of the equipment, devices, machinery, cameras, and falls on ERS. Paragraph 7 has to do with operational matters. There has been this question or concern that to the extent ERS would have materials that it could not utilize, it would want to bring those materials out here. You will accept them, subject to testing and whether they are brought out here, keeping with your other requirements and so forth. But you're not going to be open 24 hours a day waiting for that call. This doesn't say that. It merely says that you'll operate under normal hours, and ERS is going to have to make whatever arrangements it has to make if they're going to bring something out here. You don't have to have somebody on call and receive it. And there's another provision in here a little bit later, I think, to the effect that you are not going to be providing any storage for them. That's their problem. Paragraph C on page 9, this came from Bill, and it had to do, this particular version of it isn't what he had in mind necessarily. But if you have what's called an exceptional event, and that is defined in that administrative code as a flood or an earthquake or a train wreck, a couple of other things, then Bill's thought was, well, ERS probably would not be equipped to deal with the waste volume and really probably the nature of it generated as a result of that. So why don't we just put something here to the effect that the landfill will direct the disposition, which I thought was a nice thing to offer them. Well, they were concerned that as a result they would be denied some of that waste, which could be useful to them. Yeah, it's a legitimate response, I guess. So what I did was soften this a little bit and simply say that both sides will cooperate with authorities. There will be some involved in how you dispose of that waste. Waste stream, this is paragraph 9. The important part of this has to do with your statement in here. It's the end of that first paragraph in A. LNI cannot and does not guarantee or make assurances as to the following. First, as to the tonnage or timing of the deliveries. Second, as to the content of the deliveries. Third, that any of the service communities will remain a member of LNI. Fourth, that any of those communities or other waste generators will deliver or cause to be delivered their waste to ERS. You cannot control those things. There's an example. What can happen. So the expectation, if there was one on their part, that you could provide an assurance that they're going to have a certain waste stream forever and ever, certain types of generators. You can't make those guarantees or assurances, you know. Is that so? B at the top, page 10, has to do with nothing generated from outside geographic limits. Goes to them. 10, representations and warranties. Now you're getting into kind of lawyer boilerplate stuff. I'm not going to subject you to that. 11, no warranties. This is sort of the backstop for that prior provision about not being able to make guarantees 12 is the indemnification section. Originally, there was a very wordy, awkward indemnification provision that was applicable to both parties. Andy Anderson brought up the question at the board meeting as to what it meant. My answer was, I don't know. I still don't know. So what I've done with this is scrap the section that had any obligation on the landfill to indemnify ERS. Just got rid of it entirely. And what's left now is just an obligation for the ERS to indemnify the landfill. Part of my reasoning on that is that I think there's a question from a legal standpoint as to the appropriateness of municipality indemnifying anybody as to budgets and constitutional, state constitutional provisions. And I researched that and I came to the conclusion that I don't think you want to be in the position of indemnifying. It's a contingent liability that's so indeterminable and ongoing that it makes no sense. It's not good public policy. That argument was accepted, and you don't see anything here about indemnification per se. 13, limitation on damages. That I'm okay with, and I think that's useful from our standpoint. Paragraph 15 has to do with insurance. Initially, the insurance provisions that they had were, first of all, inadequate in terms of amount. The figure was $1 billion, as I recall, and there actually wasn't anything there about air pollution or pollution coverage in general. What you'll see here is the dollar amount for just general liability is now up to $5 million, and the air quality and pollution coverage is now $5 million. That's paragraph B on page 14. Termination of the agreement if there are defaults of one sort or another. For example, if ERS has not received any of the wasted needs for a period of 30 consecutive days, the agreement may be terminated by ERS. We can terminate it if they fail to perform their obligations. There is a provision E on page 15, a grace period. If there's a default, the non-defaulting party has to be noticed. The other party has a certain period of time, either 30 or 60 days to cure the default, failing which, that's it. 17, one of the critical issues from the protection of landfills side on this is that you do not in any way become a partner or a joint venture with ERS because that exposes you to certain liabilities from a standpoint. So I want to express provision here that you are not entering into a joint venture, you're not a partner. The only thing that's a little bit of a different wrinkle has to do with third-party beneficiaries, and with respect to the insurance and indemnification provisions, I think you want all of your municipalities to be third-party beneficiaries, and that's what it says. 18, 3 lines. Never a word said on that from the other side. But you know, if they want to sign the agreement, you have to consent to it. 22, the contingencies. They're within 270 days after everything's executed, but certain things have to happen. The ones that they're concerned about is financing, agreement with the City of Mason City on tax abatement, getting the licenses, permits, and so forth that they'll need, and their agreement with the LNI Energy. Speaking of which, I'm told that there still is not an agreement signed with the LNI Energy. We heard that there was an agreement in principle. I asked whether there was different treatment being afforded the landfill as opposed to the LNI, and the expectation was that we pound this thing out in a matter of weeks and have it packaged up. I don't know how long they've been talking to the LNI, but apparently nobody signed an agreement. Then you get into what I call our contingencies. We have to have approval from the state of comprehensive comprehensive plan amendment. Secondly, your agreement, your 2080 agreement has to be amended. On that, I make these comments. There is an argument out there that that 2080 agreement does not have to be amended. It is broad in scope and it doesn't have any specific terms that relate to this sort of thing. However, my reading of it and just my sense of things generally is that it was never contemplated in 1970 or at any time probably for a number of years that this sort of a proposal, this sort of option would be available to landfill. And what happened after the 1970 agreement was entered into confirms that sense, and that every community was required to pass an ordinance that in effect said that all of their waste had to come out to here or to an agent or to a site that was operated by the agency, that being the landfill. So I think that it is important that that 2080 agreement be clarified with an amendment that permits what's to happen
Yeah, all of our ordinances are specific when it comes here.
here. That's right. And that's the other
And it's,
part of this.
as you said, it's patterned after the.
That's right.
So,
That's right. If you would look at those ordinances, I would think that you'll find, for the most part, they will date within 6 months, 6 or 9 months of the date that the entity joined the landfill, either initially or later. It's a condition of joining, basically. Bear in mind that to get the 2080 agreement amended, it will take a vote of 3/4 of all of the member municipalities. There's no way to vote. 23, I'm not real proud of 23, but let me tell you what happened. That started out as a provision whereby we would try to recover from them your expenses. And I'm talking about attorney fees, consultant fees, Bill, maybe his own time that was devoted to this, all sorts of things. That didn't go over well. And the response initially was, well, our side has quite a bit of expense incurred to this point also, figuring over $100,000 or so. My response to that was, well, you invited us, we didn't invite you. In the end, all I could do was take their offer of an incentive that started out at $25,000, it's now 20, I go back up to 25 if that's the issue. It's not, as far as I'm concerned. If the contingencies are satisfied. That too, I would like some direction from the client. In terms of fees, let me just talk for a minute about that as long as we're there. I think the budget for your attorney fees for me this year was something like $15,000, and I would tell you today that I'm going to exceed that in the first quarter. And I'm relatively inexpensive. I think you know that. But between the extra meetings and this sort of thing, the hours just pile up. And it's not going to change because depending on how this comes out, there's going to be a lot more work to do. Anyway, that's basically what I can tell you about it. I think it's a much stronger agreement. It's much more protective of the landfill than what we saw initially. That was what I intended to do when I started working on it. That's my job. My loyalty to do this to the landfill. You have probably over $10 million in assets out here in terms of liquid assets plus equipment and that sort of thing, and to some extent I'm going to be at risk. And so I think we need as many protections in this as we can possibly get. I tried to look at it from as wide an angle as I possibly could, and that's where the others were really helpful because that widened my angles. But some of the things that I've tried to address in here are how could this impact the landfill financially and economically, and what can we do about that? What would it do to your operations, and what can we do about that? How could it affect your membership, and how do we deal with that? These sorts of things. In the end, to it's almost impossible to deal with all of those things, but to the extent they are addressed, I try. So I guess that's my report on this. I'd like some help on those areas where ERS hasn't reached agreement with us, and then I'd like to talk a little bit about what I think happens next as we move forward. Bill, what I forgot.
Question, that was very good.
Yeah, excellent.
Bill, which one are you working on in that definition?
That's a good example of a case where there are umpteen descriptions rather than, or definitions rather than one. We haven't settled on one yet. Bill hasn't seen this until this morning. Also, we would have thought on all the others, but we and I are going to have to meet again. Cover some stuff.
Is there anything that's totally red flag by them that they're not gonna stand for, and it's a deal breaker?
Tires might be.
They're still getting the tires, they just don't expect the customer to pay the big fee on the first 200 tons.
That's how I understand it. The reason why the language is in there now is that Bill told me that you do not have out here regular sources of tires, and that they come in more randomly than that. So it wasn't a case where we could write into the agreement something to the effect that we get all the tires from X auto company and Y auto company, and you can have to rent us. That wouldn't work. So we had to just use the tonnage for last year, and that would be the base.
In my mind, there's no difference than us getting the tipping fee for the garbage from the customer. I don't know how their operations will work. Do they want random, right now, we might have somebody brings out one tire. A pickup might bring out 10 tires or 25 tires. Do they want that traffic there? Or is it gonna have to still be here and they're gonna transport it back? That's,
My understanding was they didn't want that kind of traffic at that
Right.
facility.
And that's not really addressed in here. There was a discussion at one point, well, we want your big haulers, I guess, essentially, but we don't want the pickup trucks and, that sort of thing. I haven't really addressed that in here, because to me, it's more a matter of what type of waste they want, not necessarily how it's conveyed to them. And in any case, how do you draw the lines? Bill, in terms of what the landfill does with tires, we don't bury them, do we?
we do not.
So do we, and we don't burn them?
We don't, we ship them out for recycling.
So you bring a tire in, now you charge $10 or
Charge $2 a car tire.
$2 or whatever, yeah.
And we store them until we have enough for a shipment to go out. And then we pay for that shipment to leave.
You get a lot of traffic.
We get a fair amount, not near as much as we do car tires. I think it was of the number that Jim gave you, 90% of it was car tires.
So we don't have businesses bringing in a truckload of tires.
We might. Holland brought in 40 or 20 truck tires last week, just an example. But it's not a consistent, it's not like they generate that every month. And to call out a single tire customer would be virtually impossible.
Bill, what I got in the way of kind of an argument from the other side on the tires was that, well, the landfill doesn't bury them anyway, they don't really have a program for dealing with them, therefore, what's the big deal about us getting them without paying a fee?
Well, you go with the hierarchy again. When we collect them, they're going to another process that's going to recycle those into a beneficial product for someone.
Okay.
Maybe not the landfill, but it's going to go as again, road base or playground material. There's a wide arrangement, or wide assortment of what that can be used for.
Tires have their own waste hierarchy. If you use a tire for a swing, for example, on a tree, that I think is the top
Really?
level.
Get more points for that. Advertise.
Tree swings.
Tree swings. What up at the local land?
So I think I need to have some help on how I respond to what they want to do with tires.
Well, you're gonna get a certain percentage of tires here regardless of.
Right.
And most of your business is gonna be cars and pickups, which aren't gonna go over there anyway. So. What's that?
You still collect that?
You're still gonna collect a certain amount of tires over, so. When you fill a roll-off out here, you dump into these things, cars and pickups, dump into that. When that's full, are you gonna be expected to deliver that over to them also?
That's a great question.
Anything that we end up with that they are entitled to, they come and get.
They come, get, so they'll have their roll-offs here instead of ours.
What do you mean by roll-offs, Marty?
The boxes that we throw stuff in.
Down.
Oh, I don't know.
Well, we're gonna have to have a truck running here anyway.
That's a great question. I didn't even consider it. We have 2 boxes right out here that customers can bring garbage out of their cars and drop it in the box. And what we do is we haul it to the working face and dump it. And Marty's question is, so would that have to go over there? The initial concept that I was presented last spring, summer, was that all the loads of cars, pickups, and trailers would come here and be delivered here for disposal. That was that 20% of waste stream that we were going to retain here at the landfill. To me, those boxes are the same thing.
Yeah, I agree, you got some language in there that says it has to be directed there, and is that part of it, I guess, but, I mean, 20%.
Say they couldn't pick them up, take them back.
Right, but it had to be at our convenience.
Another context in which the question arose as to what happens to waste that comes here that they would be otherwise entitled to under the agreement. Now, I want to talk a little bit more, Bill, about your comment concerning what the original perception was, that we would get a certain stream. But the other context that I have discussed with the other side of this is this one. Let's say Popejoy decides that it is not going to play ball on this, and it's going to refuse to amend the 2080 agreement, it's not going to change its ordinance, meaning that it has to continue delivering its waste to the landfill, and its waste generators do the same now. Who would be entitled to that waste? Well, ERS thinks that that's theirs, and I have essentially conceded that if they're entitled to it, otherwise under the agreement, it comes here, and they can come get it. But if that's inconsistent with the understanding that you had, Bill, then maybe I've got to retrench my views on it, and we'll have to rethink how to deal with that.
But say they don't, Popejoy doesn't, and so they dump it off out here on the working days. Does he have to stockpile it then, and they load it when they come to get it?
Yeah, good question. You know, you'd almost have to head it off at the source. You couldn't let it go beyond the scale.
Yeah, I mean, it is, and I can see that happening. It's just,
Nice have to haul it over there.
But you've got a community that it's coming from that said that they don't want to be over
they're
there.
not gonna amend that agreement, you know? So if they don't amend their agreement, and they deliver it here, as their contract signed is stating, their ordinance is stating that we feel the contract that we signed in our case, 1990, that we we deliver waste here. What they do with it after that, I don't know. But there's nothing saying I gotta drive 10 miles round trip to go to this other place at those costs of mine.
Now, the likelihood is that if this becomes an issue, it may well be limited to the boat joist. You can't give an assurance of that, but their volume of waste I would gather is relatively, comparatively limited. Maybe there's a way that can be done, but it's an issue.
Yeah, it is.
Well, the city of size of Hampton decided they didn't want it.
Of course, it is.
I'll talk to you about that. If I can, in the next segment, what we're going to have to do. So, back to the tires, what are we going to do with that?
So basically, they're expecting all tires that